welcome to the breakdown, or me, welcome to All Rise News. I'm not sure who's welcoming who, but let me set this up for you. So, what the Department of Justice did was they were relying on materials seized pursuant to 4 search warrants in 2019 and 2020 of Dan Richman, right? That's person 2 in this indictment against Jim Comey, presented by the one and only Lindsay Halligan. So they got all that stuff, and Jim Comey and his lawyers filed a motion saying, "Hey, we think there might be some problems with this because it's pursuant to an old search warrant. There might be some issues here. We're not sure what Lindsay Halligan may have said or presented to the grand jury. We're not sure if any of what she presented is privileged, and we think it is. So we are trying to show cause here that we need to see the grand jury transcripts and hear the grand jury tapes." So they filed a motion to get that stuff. Now, this is separate from Judge Curry, who's trying to decide whether Lindsay Halligan was appointed lawfully and why they want the grand jury transcript in that particular case. This is a different wanting the grand jury transcripts. So Judge Fitzpatrick, who's a magistrate judge, said during a hearing, gave an oral order, yeah, you got to hand over all the search warrant materials so that Comey can see if anything was privileged, if any of these are attorney-client privileged communications. And you got to hand over the grand jury transcripts so he can hear what Lindsay Halligan presented, if she presented any, fruit of the poison tree, anything that was not legally obtained or seized in these old search warrant materials. So, so the DOJ filed an appeal of Judge Fitzpatrick's order that that Comey should get the grand jury material. And they said, no. This magistrate judge can't do that because the magistrate judge never said why, never gave us any particularized grounds, it's called. So, no, that's not fair. You can't hand it over because the judge never said why. So Judge Nachmanoff, the judge up a little bit higher, the federal judge of the district court, who's handling the full case, said, actually, the Judge Fitzpatrick can do that. But hey, Judge Fitzpatrick, go ahead and give them your particularized grounds for why it's okay to hand over grand jury material to the defendant, because normally you don't, because of grand jury secrecy, right? You have to have a pretty high burden of proof that something went really, really wrong in that grand jury proceeding in order to get these things. So the government was like, no, you can't hand it over. And they said, yeah, you can. Oh, and you want to know why? Okay, here's why. And that is what is in this order today, because Judge Fitzpatrick, the magistrate judge, is like, okay, yeah, you're going to hand over the grand jury materials to Comey, but let me tell you why. So here to go over this just mind-blowing list of reasons, list of particularized grounds that the judge gives for handing over these grand jury materials for Comey is my good friend Adam Klasfeld from All Rise News. We've been reading this, like me, you, Anna Bauer, Andy McCabe. We're like texting back and forth, like, oh my God, page 2. Oh my God, page 3. Oh my God, page 4. So Adam, welcome. It's going to be a busy week ahead. I wasn't expecting this to drop in our laps this morning. So talk a little bit. First of all, tell me if I got everything right in the lead up or if I left anything out. And then let's talk about what is in this particularized grounds finding by the judge.
So about 2 minutes before our Substack Live, I retrieved my jaw from the floor to prepare for this, because this is a 24-page memorandum opinion identifying at least 11 defects in the grand jury proceedings. And you got the background to this entirely correct. I will say that what he identifies, so this is our first real view into what happened in that grand jury room beyond there was reporting that the top count of the indictment was rejected by the grand jury, that it was narrowly pushed through by a razor-thin margin. but what Lindsay Halligan may have told the grand jurors, what she presented to the grand jurors. We now know that it was just Lindsay Halligan in the room. We know it is just one witness, an FBI agent who isn't identified. We know that she gave, in the words of the federal judge here, Magistrate Judge Fitzpatrick, apparently two fundamental misstatements of law, and boy, are they doozies. We'll go into those misstatements of law, but the misstatements of law are something for the record books. This is something that is beyond the imagination of the scriptwriters of My Cousin Vinny, beyond the imagination of the scriptwriters of Legally Blonde. The first fundamental misstatement of law, she apparently misstated burden of proof at an eventual trial. We don't know exactly what Lindsay Halligan told the grand jury because that part of the ruling is redacted. But we know from inference what the judge said about what she told the grand jury. And I have that section out right now. You just have to read it because it's incredible. The prosecutor's statement that redacted is a fundamental and highly prejudicial misstatement of law that suggests to the grand jury that Mr. Comey does not have a Fifth Amendment right not to testify at trial. The prosecutor's statement ignores the foundational rule of law that if Mr. Comey exercised his right not to testify, the jury can draw no negative inference from that decision. So whatever Lindsay Halligan told the grand jury in response to a grand jury question in the room was something that was so out of whack with what anyone who has ever seen a courtroom drama knows, that it botched what the fundamental, what a student, a grade school student can tell you about the way burden of proof operates in the United States of America. There was a second foundational misstatement of law identified by the judge. Second, the prosecutor told the grand jury that there was redacted. Now, we don't know the exact quotation, but here's what that redaction is about. That statement clearly suggested to the grand jury that they did not have to rely only on the record before them to determine probable cause, but could be assured the government had more evidence, perhaps better evidence, that would be presented at trial. So she botches burden of proof. She insinuates to the grand jury that if they don't meet that low threshold, they don't think that the evidence presented to them during the proceedings is enough. Don't worry, we probably have more and better evidence that we can present to you, or a different panel, I should say, to a trial jury at trial. So those are the two breathtaking misstatements of law identified by the judge among the 11 different defects that he identifies in this 24-page explosive ruling as to why Comey is entitled to these grand jury records, because it's not given to every defendant. There has to be particularized reasons stated. There has to be a very high threshold. And let me go back to, you had mentioned Daniel Richman, because the judge notes here the fundamental theory of the case that the government offered had morphed over the years, that this was originally an inquiry, that there was some investigation by the Justice Department about leaks involving Annie McCabe. And the theory of the case fundamentally changed. And all of the search records that were about the government's first theory of the case, in 2025, the government may have unilaterally, in the words of the judge, gone back to the original warrant, not to a court, and just rummaged through potentially attorney-client privilege matters between Daniel Richman, who was Comey's former legal advisor at the FBI, and is now a law professor at Columbia University, rummage through these materials that they were potentially not entitled to under the Fourth Amendment, that may have been privileged, and they made that evidence haul the centerpiece of the grand jury presentation, according to this ruling. So again,
Yeah, and let me just let it, like, kind of explain that bit to everybody. If you've got an old warrant sitting around and a bunch of stuff sitting around, here's a great example. Like, let's say you searched Rudy Giuliani's house and you were looking for materials that might have been pursuant to a crime about things he did in Ukraine. Okay, and by the way, I'm using this very specific example because this actually happened. So you go and you search Rudy Giuliani's house for Ukraine crimes. Then you're Molly Gaston, you're Merrick Garland. You get to the Department of Justice in March of 2021, right after the January 6th things, and you think maybe we should get another warrant to search that stuff we got in the Ukraine case for other stuff and other crimes, up to and including Donald Trump. This was one of their first acts when they got there after 2021. So they actually sought a second search warrant, a fresh search warrant, saying, hey, this stuff we have from Giuliani, it was for Ukraine stuff. But because we want to look at Trump and January 6th and all of that and the trying to overthrow the 2020 government, we would like a fresh search warrant. We want to go through these with eyes on perhaps those crimes from other people that weren't related to Ukraine. But we already have the stuff, but we need to get a new search warrant because otherwise we could be accused of violating Rudy Giuliani's Fourth Amendment rights and using fruit of the poison tree as evidence in a case against, I don't know, maybe Donald Trump later. So they got that search warrant. Then they set up a filter protocol team, went through it, had somebody who's not investigating look through it and see what's privileged and what's not privileged. And then when it wasn't privileged, then they made sure that Rudy got a chance to review it and have arguments about it in court because Rudy is the privilege holder because he was the one who was searched, or the other privilege holders that he might have been representing. So, anyway, they took all these very, very, everyone's like, why did the January 6th investigation take so long? It's because you have to do these things in a specific order. And what we learned today from this judge is that what happened was they just, like you said, used the word rummaged through these 2019, 2020 warrants, the fruit of those searches, did not get a new, fresh warrant for a new crime committed by a new person, and just used all that as the centerpiece for their case. And the reason they did that was because they only had 18 days until the statute of limitations expired. Maybe they were a little bit in a hurry and they didn't want to have to go back to a court and take all the time and the month or two it would take to get a new warrant and to go through privilege logs and to get all that information, all the stuff that everybody was like, why is the DOJ dragging its feet on the January 6th investigation? It's because you have to go through these processes so that you don't violate somebody's Fourth Amendment, Fifth Amendment, Sixth Amendment, 10th. Like, you have to make sure that you go through all these processes because this kind of stuff can result. Right. Where a judge goes through this stuff and says, yes, you violated Comey's constitutional rights. And he's kind of indicating here that he could throw the case out. He needs briefing on it, but that this is so bad and such so violative of Comey's constitutional rights on search and seizure that it's a massive problem for these charges.
As a matter of fact, he says in the conclusion that the disturbing pattern of profound investigative missteps might lead to that it can lead to potentially the dismissal of, and I love this language, one or more counts of Comey's 2-count indictment. There's so much that's damning here. There's a phrase that appears in this ruling that really says it all. A general warrant. He's citing the prohibitions on a general warrant, which would mean, we'll just rummage through everything that you may have said with your lawyer. A general warrant is one of the sparks of the American Revolution. We have a Fourth Amendment because of our foundational as a country distaste for the general warrants of a king. This is very much a no king's story, that particular phrase that appears in this ruling. I will also note there was a development right after the last time Allison and I spoke where Lindsay Halligan submitted a declaration to the court about a gap in the grand jury record from
the final 139 minutes have gone wonkies. It's not there.
Yes. So from 4:28 p.m. till at least 6:40 p.m. when the second indictment is returned, there's a gap in the record. And Judge Curry, who is overhearing the disqualification arguments, calls them out on it. Now, Judge Fitzpatrick takes a look at that same gap after Lindsay Halligan says, oh, the grand jury was deliberating then. Many reasons to distrust that explanation. Usually, grand jury deliberations don't take so long because unanimity isn't required, low burden of proof. But beyond that, the judge makes the point, wait a minute, there were two different indictments presented within this period.
Yeah, I have
She
this brought up. I have this brought up where
Yeah, why don't you read it?
the judge says, at some point, Halligan prepared signed a second indictment that removed count one of the original indictment. At the return of the indictment, the government presented both the first and the second indictments to the magistrate judge. The first indictment indicated that the grand jury failed to find probable cause as to any count. The second indictment indicated the grand jury found probable cause as to two counts. Both indictments were fully executed by grand jury foreperson and the prosecutor. Presented with two facially inconsistent indictments, the magistrate judge questioned the grand jury foreperson and the prosecutor to unwind this procedural knot. The magistrate judge then accepted the return of the second indictment. The second indictment was a new indictment, and therefore the undersigned concluded after reviewing the grand jury transcript, the judge, I have concluded after reviewing the grand jury transcript that Halligan would have presented the second indictment to the grand jury for consideration before it was returned in open court. It now appears that may not have happened. There is no record of a second presentment after there was no probable cause found in the first indictment. That's a massive problem for her. And I don't know, again, if they're withholding, and the judge questions too. So either that 139 minutes happened and you didn't give it to me, or it didn't happen and we have a big problem. So
Right.
we have a big problem either way, right?
Right. And there are two key footnotes. I always tell people, always read the footnotes. Here's a doozy of a footnote in that very passage. If the court is to read the prosecutor's declaration as suggesting there was no contact between any government official and the grand jury after 4:28 p.m., then it begs the question of how the then first assistant learned that the grand jury had refused to indict on one count, and how the first assistant knew which count had been rejected by the grand jury, all before the indictment was returned in open court. So he's saying it doesn't add up. And then on the next page, footnote number 12, it is the responsibility of the United States Attorney's Office to record and, if required, transcribe all grand jury proceedings. And he doesn't buy Lindsay Halligan's claim in a typo-strewn declaration where she misstated her position, and this is true, as a interim United Stated attorney, not a United States attorney, which is actually more accurate, but still a typo, said that that declaration that she submitted to the court doesn't add up, and it's the responsibility of her office to transcribe and present all grand jury proceedings in case it's needed for something just like this. I can't tell you how much of a bombshell this really is on so many different levels. It is just he cites 11 different grounds that on which you could question the grand jury proceeding to the extent that there could be a very real argument to dismiss one or more counts, more than one count, the case is gone. There's a possible violation of Comey's Fourth Amendment rights. The very legal questions that from the grand jury that Lindsay Halligan answered was a possible misstatement of the law and Constitution. We don't know the exact quotation, the words that she said to that grand jury, but we know from the judge's description that they go to fundamental things like burden of proof or suggesting to the grand jury that if you don't like our evidence, don't worry, we've got others. Just
Mhm.
assume that we have better evidence. And then by a razor thin margin, you can indict James Comey. All of this is becoming public. None of this is stuff that we knew this morning about what was said in the grand jury about what was uh, about what preceded this investigation. And so many of these things could be fatal to the case against Comey if it even gets past disqualification of Lindsay Halligan, if that's not dismissed with prejudice before Thanksgiving. The very foundation of this, it's almost beyond parody. You have to turn to Hollywood fiction to approach this level of repeated misstep. And I'm trying not to characterize it too much, but really just explain what's in the ruling. We'll post it when this video comes up. I'm going to be in court on Wednesday to see the aftermath of this. But after this video is posted, I'm sure that you'll send it. You'll show the full ruling to Allison. It really needs to be read to believed, to be believed.
Yeah. Yeah. And so the next steps, I think, as the judge sort of indicated here, is what he said. Comey gets to see all the grand jury transcripts. This is a fatally flawed prosecution. And I expect, he says, that we will get motions to dismiss this case based on grand jury malfeasance or whatever. So all of that still has to happen before the case. The judge here can't just throw this whole thing out. Comey's got to make a filing. The government has to respond to it. Now that they've seen the grand jury materials, Comey has to make a filing and say, here's why under law this should be dismissed. And he can go through those 11 different, fatalities with with this particular indictment. Also of note in here was the confirmation that the FBI agent that testified, the only testimony outside of Halligan's presentment that was in the grand jury room, uh, was possibly tainted by privileged communications, because the FBI agent, they reviewed all of that, stuff from the 2019-2020 warrants without seeking Comey's input. Comey is the privilege holder here in attorney-client privilege
Right.
Assertions. And you've got to, like they did with Rudy Giuliani stuff, you got to get a warrant to access it for a different reason. Then you got to not look at it and hand it over to a filter team and a taint team and hand it over to the person that you're looking at and say, go ahead and look through these and you tell me if there's any privilege stuff. And you got to go through that whole battle. And then the investigators can get the non-privileged communications, right? And use those. But this FBI agent that testified actually went to the Office of General Counsel at the FBI and said, "Hey, I've been exposed to taint. I've seen fruit of the poisonous tree." And at some point, the DOJ decided, "That's all right, pal. Go in and testify anyway. Give it your all." And that
And
is
it's the center that evidence, that particular evidence is the central evidence, according to the judge, that led to James Comey's indictment on 2 charges. Uh, I saw someone asking about the blowback for Halligan, and that's a very good question. There's already a complaint that has
to the
been
bar. Yeah.
filed. Yeah, the bar complaint. But to Allison's point here, that I don't think this reflects badly only on Lindsay Halligan. There is that, according to this ruling, that FBI agent knew that was privileged material. I believe that's what the judge said there. The judge also said that the second time that they tried to get the warrant executed, on the original warrant was looking for violations of different offenses. They didn't seek a separate warrant. And that procedure was apparently endorsed by the then Eastern District of New York under folks who would presumably know better. So we'll see what the fallout is. This is an
Right.
explosive ruling on more than one level, what it means for Comey's case and what it means for every person who touched these potential constitutional violations. I would be interested in speaking to an ethics lawyer on that question. I don't feel qualified to say it, but in terms of just reading the ruling, and the type of conduct that that imputes not only to Lindsay Halligan, but to an FBI agent and to the Eastern District of Virginia in early September for the second search, when they were trying to beat that statute of limitations clock and needed different evidence and made that evidence a
Right. That
cornerstone.
Fourth Amendment violation happened under the previous Eric Siebert, right?
Right. A
Was it?
highly respected U.S. attorney who was apparently, from the looks of this document, bending over backwards before taking that ethical and stand to saying, I'm not going to be involved with this. And I think he would feel very vindicated about that now, to see all of that entirely implode in this ruling.
Yeah.
Folks
And I
just
have
need to read this.
what the judge says here about the privilege from that agent.
Right.
The judge says, while it's true that I did not immediately recognize any overtly privileged communications, because he reviewed all this in camera, it is equally true that the materials seized from the Richmond warrants were the cornerstone of the government's grand jury presentation. The government substantially relied on statements involving Comey and Richmond in support of its proposed indictment. Agent 3, the guy who testified, referred to these statements in response to multiple questions from the prosecutor and from grand jurors, and did so shortly after being given a limited overview of privileged communications between some parties. The government's position that privileged materials were not directly shared with the grand jurors ignores the equally unacceptable prospect that privileged materials were used to shape the government's presentation and therefore improperly inform the grand jury deliberations. So
Right.
you'll recall, I can't remember what show it was on, but I said, even if Lindsay Halligan or this guy didn't give actual privileged communications to the grand jurors, the reason you have a taint team is because anyone who has seen these materials is tainted when they answer questions about it. Even if you don't give privileged material, it's in your head, and therefore you are a walking taint bomb. You can no longer be part of this.
Right.
Does that make sense? And so that is exactly what the judge is saying here. It's not just about whether you directly get, and this probably shows the incompetence of Lindsay Halligan. This is why it doesn't matter if you directly give privileged information from these warrants to the grand jurors. You saw the stuff and you're answering questions and you're a tainted person. So
Right.
that is in itself inexcusable in delivering grand jury instructions or presentments to the grand jury. So
Right.
just every sentence, like you said, pick your jaw up off the floor, because every single paragraph in this ruling has something just insane in it. The fact that she said the burden of proof is on Comey,
Yes.
that
It's
Comey is guilty until proven innocent by himself, is just
we
bananas.
knew when she was her first time in the grand jury room. She's never been a prosecutor, that she was going to get stuff wrong. The burden of proof, that she would suggest also that, oh, don't worry, you don't need to worry about the record before you. Just assume we have better evidence than the evidence that may have been illegally obtained. I'm going to read that passage about September 12th. That was when so as part of the investigation on September 12th, this is days before Siebert's resignation, an FBI agent assigned to the director's advisory team was instructed, apparently with the concurrence of the U.S. Attorney's Office up in the Eastern District of Virginia, to review a Blu-ray disc that contained the full Cellbrite extraction and reader reports of Mr. Richmond's iPhone and iPad backups. Inexplicably, the government elected not to seek a new warrant for this year's search. 2025, it says, even though the 2025 investigation focused on a different person, was exploring a fundamentally different legal theory, was predicated on an entirely different set of criminal offenses. The court recognizes that the failure to seek a new warrant under these circumstances is highly unusual. I mean, this is just a scathing decision, and we didn't even read the conclusion and the
11
introduction.
things.
A disturbing pattern of profound investigative missteps that led to an FBI agent and a prosecutor to potentially undermine the integrity of a grand jury proceeding. A rare example of a criminal defendant who can actually make a particularized and factually based showing that the grounds exist to support the proposition that irregularities may have occurred in the grand jury's proceedings and may justify the dismissal of one or more counts of the indictment. I mean, it's
Yeah.
a furious ruling.
And Adam, I was so worried that we wouldn't get to see this kind of we wouldn't get to see Lindsay Halligan shit the bed because
Mm.
I thought they were going to dismiss this case on her unlawful appointment and we would never get to know what went on in the grand jury room. But the best part of this whole thing is that the reason we're getting this information is because the government asked for it and demanded it. The government said, "No, no, 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 you've got to give us particular grounds, for this." And the judge was like, "All right, you want it, you got it. Here they are." We would not if the government just handed this stuff over to Comey, we wouldn't know about any of this today. But
Right.
because they objected and said, "Sorry, Judge, you got to tell us why." It's like, "Oh, you really want me to? All right, here we go. You ready? Here's 11 things that you screwed up really badly." So thank you, Department of Justice, for demanding the particulars on this case and why, because we might not have known otherwise. Because again, if they had just handed it over and then the other Judge Curry, if she dismissed this case on an unlawful appointment, we might not have known any of this. But because the Department of Justice demanded the reasons, we have them.
Right. And it'll be interesting to see what Fitzpatrick says on Wednesday, because this comes right before a hearing on another wave of pretrial motions, any of which, whether on vindictive prosecution grounds or dismissal for one of the ways that Comey has challenged this that could come up at this week's hearing is that what he said in his 2020 testimony is literally true, and the questions given to him by Ted Cruz are fundamentally ambiguous. But the judge might comment on all of this.
Yeah,
On
I'm not sure. I'm not sure because this particular hearing is supposed to be for those first two motions.
Right.
Which one of them went to Judge Curry, the lawfulness of her appointment, and the other one is vindictive and selective. But
Yeah.
it's all intertwined, as
Right.
Fitzpatrick said in his things. He's like, the vindictive and selective is intertwined with the grand jury presentment and the potential grand jury malfeasance and the Braunston literal defense. But those later motions, Braunston literal defense and all that other thing, that's supposed to be heard on December 9th. They're asking for December 3rd, 4th, or 5th. I don't think I've seen that that's been moved yet, but they're asking for an earlier date because Comey's lawyers have a different trial they have to go to on December 9th. But nothing ever, precludes a judge from bringing stuff up in a hearing. Like I don't think we'll hear him say, "Sorry, we're not going to talk about that today because that's scheduled for the December hearings."
Right.
Because it's all intertwined, and because Fitzpatrick said that it was, that might come up. And Adam, you're going to be there now.
I will.
Am I correct in thinking that this is the court where you're not allowed to even have your phones in there?
That is correct. You are not allowed to have your phones in the Eastern District of Virginia. They are very strict about it. So I am there with a pen and pad recounting what happened after the hearing once I see it. It's interesting. The last time I wasn't in court for this particular hearing, but the last time that Fitzpatrick presided over a hearing in this court, he said that the government's MO in this case was indict first, investigate later. So this is a judge who doesn't hold back on laying into the government, particularly in this case. He just gave one of the most blistering decisions I have read this year, in a year of blistering decisions of judges warning about the attack on the rule of law that this administration presents. This is really up there. So what will he say in court? So Wednesday's looking a lot more interesting. And remember also, this is a ruling allowing the defense to have access to this grand jury information. What will they say about how this may boost, in some ways, the arguments on the other motions? As you said, Allison, it's intertwined. And so, yeah, we'll have a lot more to talk about very, very soon.
Yeah, we sure will. My friend, thank you so much. Everybody, thank you for listening. I just want to address something that Truth to Power, who is here, said. They said Adam and Allison, super lawyers. I just want to be clear. I am not a lawyer. I have never gone to law school. I've the School of Hard Knocks Law School I've gone to, but not actual law school. I do not have a JD. Never set foot in a law school classroom, but I have watched My Cousin Vinny and Legally Blonde. So I do, and when you texted me that, like, this is far even too fanciful for the writers of those movies. I was like, dude, Vinny and Elle Woods are much better lawyers than.
Oh, absolutely. Uh, and to be fair to Halligan here, it's her first time out there, but even for her first time out, come on.
This
And
non-lawyer would have
this
done better.
Yeah, absolutely. And look, you cover courtroom proceedings. I'm a legal journalist, and I've covered it for nearly 20 years. You get used to describing procedure, and you get used to what is unusual, what is common, what is uncommon. And as a journalist, I think both of us can say that I've certainly never seen anything like it.
No.
Obviously,
Mm-mm.
this isn't the first case where the government has been accused of serious misconduct, but there, as we approach Thanksgiving, really seems to be a cornucopia here of lots of different jaw-dropping moments, from alleged Fourth Amendment violations to alleged misstatements of the most fundamental concepts of U.S. law that the grand jury is asking about and may affect their deliberations when they indicted Comey by a razor-thin margin. There has not been a case like this, of this many profound, um, in the words of the judge, profound uh, allegations of government misconduct, and a record of just a total farce.
Yeah, and I hope we get more. I hope the judges here continue, whether it's Judge Curry, Judge Fitzpatrick, Judge Nachmanoff. I hope they continue to try to get to the bottom of all of these motions to dismiss before they just dismiss on one of them, particularly she's unlawfully appointed and therefore the whole thing is moot. Because I hope they're sitting around saying, look, we've got a rule on all of this. The people need to know what the Department of Justice did here. And so I hope that that's something that they're thinking of doing, because, again, the only reason we got this information today is because the Department of Justice demanded it. You have to tell us why, or Judge, or you can't make us give the grand jury stuff to Comey. They really didn't want this grand jury stuff to get out, and now I can see why, Adam. And I know that you're going to be traveling and doing a bunch of going to court and a lot of hearings this week, including Abrego Garcia and including this particular case, the Comey case. And so, everybody, if you have the means to support All Rise News financially, his stuff is free. But if you have the means to support it financially, please do, because it helps him travel. He doesn't have corporate overlords at All Rise News that just pay for his, plane and lodging and stuff. So that every little bit helps. So I just wanted to say that. And if you have a chance to subscribe to my Substack, Mueller She Wrote, I would love it if you did. It's all my content is free. Nothing is ever behind a paywall. And again, if you are able to support independent journalists, great. If you have the means, if you don't, just subscribe for free and get all the content. It's totally fine. We appreciate you supporting independent journalism and independent media. So thank you so much, Adam. I'm looking forward to your coverage of this hearing in particular. And thanks to, 2,500 people on a Monday. Thank you for joining us. And we really appreciate you being engaged, understanding what's going on in the courts right now is so vitally important. And that's why I rely on folks like Adam Klasfeld to bring us the information. Do you have any final thoughts before we get out of here today, Adam?
Thank you so much, Allison. I think that it's a very interesting time to be covering the legal system, to be focused on the law, the way we are seeing this develop in the courts because of this unprecedented attack on the rule of law, but also see how information does come to light, what happened in that grand jury room, even a grand jury room where secrecy is most intense, presumed to be the most intense, that when things go that far awry, to see that it can come out into light and transparency, it's gives a little bit more faith in both the system and the a journalist's place in it to communicate it. Thank you for also pointing out that, again, it's going to be a week of live coverage. I'm going to be in Alexandria, Virginia on Wednesday, and then Greenbelt, Maryland on Thursday and Friday. There's an Abrego hearing tentatively scheduled for Thursday. I will be there if it is confirmed. I'll be there on Friday if John Bolton's hearing, which is firmly scheduled for the first in his road to trial. And if you can support that work, yes, it's in All Rise News subscribers that allow me to go on the road into the courtroom and show exactly what the government is up to.
Yeah, and somebody had said, plus Adam Klasfeld is a sweetheart.
Ah,
Um,
sweet. Thank
and
you.
I want to say that something I've learned in all the many jobs I've had is that the most successful people are the people who are kind. And I can say Adam Klasfeld here really helped me out, particularly during the hush money trial, along with Anna Bauer and Kyle Cheney and some other journalists, really helped me figure out how to get in, where to get in line, how to get into the room, what not to do, what to do. And I have never met kinder people than the folks that I work with and have discussions with about the courts than people like Adam Klasfeld. So being a sweetheart, although I'm not sure what the intention behind that particular comment was, uh, is such an important thing. That the two biggest lessons I've learned along the way in these past 8 years doing what I'm doing is that you have to work hard and be kind, and you're a very, very kind person, Adam. So thank you so much
Thank
for all of that and all of your support and help. And
And you have been extraordinarily kind to me. I did have to answer that as well. And I will say one of the great things about this beat, folks see the news when it gets to them and everything that goes into the making of that. I think the press corps helps each other out. You've helped me out more times than I can count, and glad that I could do the same.
all right. Well, thank you, everybody, all of you as well. Thank you for being so kind and joining us today. And we'll be, I'm sure, jumping on here more as the week goes on with all of the, on the ground reporting that you're going to be doing. So make sure to, at the very least, subscribe for free to either All Rise News but preferably morrisroad.com, the breakdown. Really appreciate everybody joining us today, and we'll see you next time. Thank you.